Welcome to a fresh episode of Legal Wrangle, where we will track major judicial developments relating to income tax. For this, we have selected three important cases. The first one deals with the expression initial assessment years in the context of Section 80 IC benefits. The second one deals with validity of order passed by SETCOM on the basis of oral submission of the department. And the third one deals with the necessity of conditional pre-deposit for hearing of stay petition. The taxpayer whom we are going to discuss in our first case is an industrial undertaking set up in the state of Himachal Pradesh, which has sought deduction under Section 80 IC on its entire profit for first 5 years. Now let's understand what exactly happened in this decision.
In the instant case, the assessee company was availing exemption at 100% on its profits for a period of 5 years. Subsequently, in between same period, the assessee carried out substantial expansion and claimed that it should be allowed exemption from profits for another 5 years at 100% instead of 25% from 6th to 10th year as well. Interestingly, it admitted that the total period during which it was entitled to exemption would not exceed 10 years. As per the mandate of Section 80 IC 6. In this backdrop, the question was raised as to whether the assessee could again start claiming 100% exemption for the next 5 years from profits, after availing the same for first 5 years on ground of carrying out substantial expansion. The High Court answered this question in the affirmative and held that the newly set up industry under Section 80 IC 2 would be entitled to claim exemption on its entire profit again, if it carries out a substantial expansion in between. Let's see what the final outcome of Supreme Court larger bench was. If an enterprise sets up a unit in the state of Himachal Pradesh as per Section 80 IC 2(2), it is entitled to deduction of 100% profits for 5 assessment years commencing with the initial assessment year.
Here are the key takeaways. Benefit of Section 80 IC is admissible not only where undertaking set up new unit and start manufacturing articles, but it also available to existing unit which carry out substantial expansion of their units by investing required capital in relevant assessment year. The definitions of initial assessment year used in Sections 80 IB and 80 IC are materially different. The definition of initial assessment year contained in Clause 5 of subsection 8 of Section 80 IC can lead to a situation where there can be more than one initial assessment year within the tax holiday period of 10 years. Now let's move on to our second case, where the High Court was approached to quash the action of Settlement Commission in permitting the Principal Commissioner to supplement the report submitted by Commissioner by way of oral submissions which were beyond the contents of the report.
Now let's understand what exactly happened in this decision. In the instant case, the premises of assessee firm as well as their partners were subjected to search proceedings, wherein certain documents were seized, although no worthwhile cash, jewelry or investment was found. Thereafter, the assessee approached SETCOM along with an application under Section 245C1. It also submitted a statement making full and true disclosure. The said application and statement came to be accepted by the Commission under Section 245D1. Subsequently, the jurisdictional principal CIT filed additional submissions by way of a supplement report under Section 245D2B, and placing reliance on the same, the Commission passed an adverse order under Section 245D2C. Let's see what the final outcome by High Court was. SETCOM cannot pass order based on auxiliary submissions of CIT to bolster incomplete report challenging validity of taxpayers' application for settlement.
Here are the key takeaways. The provisions of Section 245D does not empower the jurisdictional CIT or principal CIT to raise objections against applications filed before the SETCOM if such applications has not been found to be invalid by the Commission. During the course of hearing, the SETCOM is obliged to confine itself to the contents of report filed by CIT and not to consider any additional submissions made to supplement an otherwise incomplete report. Now let's move to our last case where the SSE company had approached the writ court contending that their request for stay of demand had not been considered on merits at all, and that the concerned assessing officer had required them to deposit 20% of the demand as a precondition for consideration of the application for stay of demand.
Let's see what the final outcome of High Court was. Imposition of conditional pre-deposit is not necessitated in every case seeking stay of demand. Here are the key takeaways. Tax officials have to apply their mind to decide an application for stay of demand, and hence the stringency of conditional requirements of pre-deposit depends on facts and circumstances. Revenue officers are not statutorily obliged to impose pre-deposit as a conditional requirement for considering every pending application for stay of demand.
With this, we wrap up this episode of Legal Wrangle. Next time, we will bring some interesting cases from the world of indirect taxes. Keep watching TIOL Tube. Thank you for watching. Goodbye.